Hello and welcome to this webinar on coronavirus and homelessness, part 1. I'm Justin Bates and my co-presenter today is Mark Prichard. We'll introduce ourselves in a little bit. A couple of formalities before we can move into the thrust of the seminar. Despite the fact that I am a practicing lawyer, I didn't actually insert this slide. This is a slide that Mark required to be inserted to mean that you're not allowed to sue him if anything that he says in this seminar turns out to be wrong. If I say anything in this seminar that turns out to be wrong, it's obviously because the judge got the law wrong rather than because I actually got it wrong. But in any event, on a more serious note, we're having this discussion because we think there are some interesting issues in here and we'd like to share our thoughts and we'd like to hear what you think about some of the problems that we're raising. This is not intended to be full-on legal advice, and frankly, given how fast the regulatory position and public health position is changing, it's pretty hard to see how it ever could be legal advice. With that out of the way, let's talk a little bit about who we are and what we're planning to do over the next couple of days. I'm Justin Bates, I'm a barrister at Landmark Chambers. I am the editor of the Encyclopedia of Housing Law, available in all good bookshops for the mere price of £1,000 a year, and I'm one of the authors of this book on homelessness as well. And Mark.
Good morning, I'm Mark Prichard. I haven't been called to the bar. I'm not a barrister. I'm not at Landmark Chambers, even though the slides would suggest so. I'm an independent housing consultant contractor. I spend a lot of my time, it seems at the moment, training homeless teams, but not only homeless teams, charities and other people on housing issues, including homelessness. I've spent a lot of the last 2 years training people on how the homelessness system has changed and what the rules are governing people who go to their local council and ask for help on the basis of homelessness.
The way this came about, Mark and I have quite niche interests in incredibly obscure bits of housing law. And Mark either emailed me or I emailed Mark, probably Mark emailed me, about something or other to do with coronavirus and said, what do you think about this? And it got us chatting by email exchanges. And then we thought, well, look, there's some really interesting stuff in here that doesn't have any obvious answers, but there's a general benefit to talking through whichever side of the debate you're on, whether you're acting for a local authority or you're acting for a homeless person, or whether you are a government lawyer and watching this. And what we thought is, well, rather than just the two of us emailing each other at increasingly antisocial hours of the day, why don't we actually just talk about it, put it up on the internet, and anybody who wants to listen to it can listen to it. And so that is what we are doing. The basic idea is we'd like to talk about how coronavirus affects the position under Part 7 Housing Act 1996. We may touch upon the position in Wales by way of contrast, but just to be clear, this is not intended to be an English and Welsh seminar. This is about the position in England. The divide is as follows. Part 1 is today. We're going to have an overview of what the response to the pandemic has been, and we'll talk about how the pandemic impacts on questions around what is an application, eligibility in particular, how are we housing all these ineligible people? And then we'll look at how the pandemic affects the concept of homelessness. And then tomorrow we will do intentionality, priority need, local connection, and discharge of duties. So we're trying to follow through the path of a traditional homelessness application by looking at each of the stages of the test and working out how the pandemic affects it. Now, this was intended to be a live webinar on Monday morning. Unfortunately, owing entirely to incompetence on my part, that isn't possible, and we are recording this on Friday afternoon. At the time you are watching this, I will be being a teacher to my son, which I'd forgotten about when I agreed to do this on Monday morning. So this is recorded, and that means we are going to slightly play around with how we'd normally do questions. Please, if questions come up during the webinar, do stick them in the chat box in the usual way, and we'll pick them up tomorrow morning, on Tuesday morning. Alternatively, you can email webinars@landmarkchambers.co.uk, and we'll pick them up there, again, tomorrow morning. What we'll probably do as well at the end of both of these webinars is we'll pull together common themes from your questions, and we will try and answer those by way of a written circular. Although again, there will be a whacking great disclaimer on it telling you not to sue us if it turns out that anything we say is wrong. And hopefully you're going to find this useful over the next 45 minutes to an hour or so. And with that in mind, pass over to Mark to bring us up to date on where we are and how we got here.
Thanks, Justin. I think we'll all be familiar with the background to the issues that we're going to talk about today. I suppose one of the significant events was the letter from the Minister on the 26th of March 2020, where even though statutory services, voluntary services, the third sector had started taking action in relation to kind of safeguarding people, there was a clear kind of instruction from central government to local government, by which they were saying it's our joint responsibility to safeguard people. Clearly, look, there's a massive public health risk here. And all of a sudden, of course, whereas homelessness hadn't really been at the top of the political agenda, suddenly the most extreme form of homelessness, rough homelessness, suddenly is very important to central government. Clearly, we can't really tackle the risk posed by COVID-19 if we have loads of people, hundreds of people on the streets who are not able to safeguard themselves from the virus. That letter actually said quite a few interesting things. It says, well, it's our joint responsibility to safeguard. I've picked out a few of the key points here. It must be our strategy. Everyone must actually act to bring people in off the streets. Some interesting words: using alternative powers and funding to help those with no recourse to public funds who require shelter and forms of support. And I'm sure Justin, when he talks about eligibility and the problem, some of the questions posed will come back to that, because it seems to me that's quite a significant kind of benchmark at the outset. So councils were instructed that they urgently needed to procure accommodation, and this included taking people from those forms of accommodation or night shelters that were not sufficient in terms of mitigating risk into self-contained and suitable accommodation. And of course, as well as utilising our commission services, as those of us at local authorities, there was a whole range of accommodation solutions that were quickly procured and put into play. And sort of that, I think, what am I right in thinking the 26th of March was a Thursday or Friday, and we were given a couple of days, or certainly by the end of next week, it was expected that we would have this problem sorted. You know, this rough sleeping problem that has bedeviled us for years, suddenly we'll have it sorted. And a lot of very good work was done. You know, local authorities and the third sector pulled out all the stops. You know, really was a lot of great work done to actually meet that instruction by government. Also, in relation to funding, that original letter said, well, you will have grant funding and that will cover costs incurred in the first phase. And we'll go on to talk about funding a bit more now, because I don't propose to set out in full detail all of the different tranches of funding that central government have announced. Certainly there's been 2 lots of 1.2 billion kind of overall funding announcements, whereby local authorities are given a big lump sum of money. It's not ring fenced, it's to cover a wide range of statutory functions. Also, there was a figure of 3.2 million in March, which was specifically supposed to deal with emergency shelter. And also, I think in May, there was a figure of 160 million, which was rough sleeper funding, which was brought forward from subsequent years of funding. But I think the key thing, certainly because we're going to talk today and tomorrow about, well, how does this all relate to Part 7? How does this all relate to the administration of a homeless application? I think it's fair to say with funding that, you know, councils are already saying, well, hang on, that's fantastic, that's all very well, but it's not going to meet the cost of rehousing everyone, moving everyone on, providing support for everyone so that we can ensure that those that are entitled to housing or indeed need shelter are accommodated. So I think it's the big point there is that, again, we're going to talk about a mismatch between law and practice, and this is backed up by a mismatch in the funding realm. Also, moving on a bit more to the legal aspect, it's also interesting that there's been a lack of statutory guidance, and I think, Justin will probably say a bit more about this in due course, but when we're talking about legal issues, and I'm not a qualified lawyer, but when we're talking about legal issues, there's a big distinction between the government saying, well, this is a guidance that has statutory effect, you must have regard to it under Section 182 of the Housing Act, which is why the statutory guidance on homelessness is so important. You must have regard to it, and if you deviate from it, you might have to give reasons and justify why you're not having regard to it. The guidance that we're having, or the instructions, is not in that form, and that is quite significant. Also, many people watching this webinar will probably be aware, but it is an important point to make, the government haven't actually amended the statutory framework whereby councils are obliged to take certain action to assist homeless persons. That is significant. I think, and I'm not a social care expert, but I think it's fair to say in social care there have been some changes by virtue of the emergency legislation. That hasn't been the case in homelessness. And I think while we want this seminar to not be sectional or not just come from the perspective of councils or legal advocates and applicants, from the local authority side, I think it's fair to say that with the best will in the world, with all the hard work they've been done, with their resources being stretched. I mean, I've talked to some council managers where their homeless officers, some of them have, of course, had to be off sick, have not been in work. And with all the kind of getting everyone in, I think it's fair to say, it's fair to assume that a lot of councils will have a bit of a paperwork lag, and that can manifest itself in a few different ways. Most basically, if you talk to a homeless person who's being accommodated under Everyone In, I think it's my guess that not every one of those will have had a communication from the council which has said to them, well, this is the basis upon which you are being accommodated. They will not necessarily know the basis upon which they're accommodated. They will not necessarily know, for instance, well, am I being administered under Part 7 of the Housing Act? Is this a homeless application? Well, I have spoken to a lot of, to some homeless managers, and most of them, in fact, all of the homeless managers I've spoken to have been keen to make sure, well, we use this opportunity, and that means for a lot of people, we will administer them as homeless applications. But nevertheless, there is possibly that paperwork lag, people not even being informed of the basis upon which they've been accommodated. So local authorities are going to, I suspect, in a lot of cases, be playing catch up, and that could have implications in terms of the specific duties they're owed, and if they've accepted a duty of any kind, when they can be discharged. Do you want to go on to the next slide, Justin?
Yeah, sure.
So, as I say, when I've spoken to homeless managers, they do recognise that this is a historic opportunity. But having said that, if there is questions over the future funding, and also if we are facing potentially the end of the stay on possession proceedings towards the end of August, and we are facing not only a problem with historical people we've accommodated, but a fresh wave, and a wave which some people have described as a tsunami, because there's potential for so many people to have problems with their existing tenancies. There is questions, I think, where we wonder, well, what is the implication in a legal sense of, and where do we go from here? I think it is fair to say that there is very much scope for contentious arguments, because if the government haven't confirmed in statutory guidance how you are supposed to deal with people, and if there are debates about the underlying legal entitlements to people, which we'll come on to when we talk about eligibility and homelessness, etc., I think it would be useful to just flesh out what the scope is of those arguments, what the most likely arguments are on both sides, and to try and kind of pick our way through, hopefully during the course of these 2 hours, as to where we go from here.
So then let's turn to logically the first question, which is someone who's being accommodated under the everyone in process, have they actually made an application for assistance? Now, there's actually not an awful lot of case law or guidance on what an application is. Indeed, applications don't really exist in a vacuum in the 1996 Act. It's application tied to reason to believe. It's application tied to inquiries. This isn't like, say, a disabled facilities grant where there's a form to complete, or even a Part 6 application where there will generally be some kind of material you have to provide. What matters, according to the relatively limited case law, is that someone comes along and gives you as the local authority enough information to cause you to have reason to believe that they're homeless or threatened with homelessness. What does that mean in the question, in the context of everybody in? I think there are 3 things to talk about in order perhaps of importance. One is, there are old cases like Castelli or Streeting, that say that someone who is committing an offence under the Immigration Act, i.e. because they are unlawfully present in the country, can't actually make an application for assistance. So what do you do, or what have you been doing, with anyone who is committing an offence under the Immigration Act? Now, that probably isn't a massive category, I accept, but that's one just to think about. The second category is capacity. We know, of course, that if you lack capacity to be able to make a decision to accept accommodation, then you can't make an application under Part 7 either. What you actually need to do, following the WB case a couple of years ago, you need to have your deputy under the Court of Protection apply on your behalf. Now, everyone in is aimed at street homelessness. Street homelessness goes hand in hand with capacity problems, sadly. So what is the position if you've housed someone who lacks capacity? And thirdly, and I think probably the biggest difficulty is, if you've just taken someone in off the streets, is that enough to give rise to an application being made? And I say this is the most difficult one because, of course, you'll know that the Section 213B referral duty, the Code of Guidance says that just simply being told that someone, by the GP, let's say, that someone is homeless is not enough to trigger an application. Now, whether the Code of Guidance is right or wrong about that is another question, but that's what the Code of Guidance says. So if you've just housed someone without them doing anything proactive to suggest they want any help, does that amount to an application? What do you think, Mark?
I think I did start to wonder a few weeks ago whether, and all these questions and the extent to which they will become relevant, I guess, depends upon the extent to which local authorities are able successfully to move on people into sort of more settled accommodation with support. I mean, you know, we haven't solved homelessness at the moment. We've just kind of took rough sleepers off the street. They're in hotels. Those contracts, many of them will end. But I think, you know, when I'm training on homelessness, I'm always kind of, when I talk about this question, I'm always talking about the second limb in the statutory test. We're always talking about, well, have you got reason to believe? But it is on the face of the statute that somebody has to either apply for accommodation, well, they won't have done that in any formal sense, or they had to have made a request for the local authority to help them in obtaining accommodation. It does seem to me there is a pretty fundamental question which could come to the fore, particularly if local authorities, if they don't accept in certain cases, this is a Part 7 case, you could be then into arguments. Well, how did they come to be in the Travelodge on the 28th of March? What conversations were had? I've got in my mind kind of conversations where they're approached by the local authority or somebody acting on their behalf at their instruction. There's a discussion about coronavirus, but what was actually said, and is there kind of positive response to that, well, we can accommodate you, actually a bona fide request from the person to the council for accommodation? I'm guessing that, well, in a lot of classes of case where, look, these are potentially vulnerable people, they'll be dealt with under Part 7, there won't be an argument. But I do wonder how the courts will actually deal with that.
Yeah, I think your first point is the critical one, where you said this isn't really the issue for the moment. This is the issue for the move-on stage. Because you would hope that in a lot of cases, maybe even the majority of cases, the people that are currently in the Travelodge will find something else. Whether that's through the formal mechanisms of Part 6, or whether it's through the Care Act, or whether it's through a charity, I'm less concerned about for the moment. Because at a practical level, people who were street homeless 3 months ago, who are now housed, are, I suggest, probably not going to have a priority decision to go and find a solicitor to try and challenge intricacies about under what power were they being acted on. The problem is going to be the people who are in travel lodges who they can't find anywhere to put them. And are they going to go back on the street? Because at that stage, that person should well get a solicitor who says, well, look, hang on, they applied under Part 7. And that's where I think the problem will come about. It'll be that difficult move-on scenario. So then it comes down to, as you say, well, what the heck is an application? Because we never look at it in the context of a particular form or substance to it, because it's always allied to the second part of the test. But that's where knowing what the authority did when it approached the person on the street, I mean, it's quite an unattractive answer, but will it end up turning on what was said to each individual person at any given time? Presumably, the person who was on the street and who is now in the travel lodge has consented to being so housed by the local authority. I mean, we don't have sort of South American fascist government powers to just go and round up street homeless people and put them places. So it's obviously consensual. So on what basis were the authority acting? It must have been in response to a request. The authority surely said to the person, hello, Mr. Smith, you're presently sleeping in the car park. We can put you in the travel lodge. Would you like to? If he says yes, at that stage, do they have reason to believe?
Yes, and it might be that even if there's a kind of tricky factual kind of dispute in relation to the initial emergency housing, well, yes, it would seem to me that if you've been on the street and now suddenly you've got this opportunity, you can get your life together, you're out of the maelstrom, well, it doesn't stop you going back to the council and saying, well, I do want accommodation. So it might be that this isn't an issue, except where they're obviously, that they're an immigration offender or some other reason. But I suppose the reason why it's likely to be tricky is because I'm guessing that a lot of local authorities won't have had time to kind of document exactly what was said, won't have had time to record on their system exactly what's happened. So again, you're kind of trying to mop up after, really. I mean, and you mentioned housing solicitors. I mean, my advice when I'm approached by, even though I do a lot of work for local authorities, my advice to someone who comes to me for advice, and be no less in this situation, would be get an advocate, get it confirmed. You know, I think there's all the way through what we're going to be talking about today and tomorrow, there's going to be a lot of points where actually you want somebody to ask the council, well, we haven't got anything in writing. You do concede this is a Part 7 application, don't you?
Can I just throw one other one at you? And I'm not sure there's an answer to this one, but this is the other sort of strand to my thinking, is what does our coronavirus response mean for our post-coronavirus administration? Because eventually coronavirus will go away, and then we'll go back to the pre-coronavirus world. How about if seeing a person on the street and approaching them is an application by that person? How far do you take that? For example, is counting the person for the purpose of your annual count of how many street homeless people there are? Has that person made an application if you speak to them? Just to check, hello, are you street homeless?
I personally, I just have real difficulty with that. Not because from a policy point of view, that would be fantastic. You know, let's actually start solving the problem of homelessness. But given that we're talking about the legislation, I have real problems with, you know, that shows the kind of the difficulty, because you go back to the statute and there is something from the service user that has, you know, it's predicated on a request, an application, them wanting something of some kind. And, you know, it's interesting when you go back to a lot of the kind of tried and tested commentaries that we always use, you know, the legal commentaries, you wrote one and there's another big one. You know, sometimes you'll find a discussion about deemed applications, and the kind of the accepted wisdom until now is, oh, no, there's no such thing as a deemed application. And of course, this question hitherto normally arose where councils were trying to evade their responsibilities in the context of, well, we're going to evict you next week, but we'll take an application ahead of the eviction, even though you haven't approached us. I just think that kind of concept of, oh, we have spoken to somebody, no request was made, it was just during a street count. If you compare that to the wording of the Act, that's kind of problematic.
Yeah, although I say, as against that, this is the last point on it, I think, as against that, there is no form, it's a really low standard, and turning up to the council's offices and saying, I'd like an allocation of social housing, i.e. a Part 6 application, can be a Part 7 application. So what's the bare minimum? Is the bare minimum a physical act by the person saying, help me? Or is the bare minimum enough information to mean that the authority have reason to believe? I think that's where the debate comes in. And as I say, I think you're right. I think where this will be a problem is the move-on cases. But anyway, let's turn up, if we haven't just put everyone off, having seen the first one of these will go. Can we talk about what I think is by far the hardest bit, which is eligibility? And you and I have already had this discussion at least twice, trying to work out what we think the answer is here. I mean, look, at the best of times, eligibility is horrific. It's the kind of thing that you want to make sure you've got a wet flannel wrapped around your head in a dark room before you grapple with. But everyone on this call knows enough about it that means that I can summarise it quite briefly. Look, Section 185 provides that you're not eligible. If you're not eligible for assistance, you can't be assisted. And then there's a detailed system of working out who is eligible. So are you subject to immigration control, in which case you are excluded, unless you are re-included by various of the regulations that get made. But in general terms, if you are not eligible, that's the end of it. I'm ignoring restricted cases for the moment and priority need because that's an unnecessary complication for this discussion. In general terms, if you are not eligible, you don't get assisted. And there's just been no recognition of this by central government or by any of the material that's been sent out. I mean, you're right, or the non-statutory material. So if we look at that letter of the 28th of May from Luke Hall, for example, that's the one where he expressly says nothing has changed about no recourse to public funds. But he also seems to say that there's a human rights exception and you can house people where failure to do so would lead to a breach of their human rights. But on what basis? 185 isn't a power to do that. It doesn't have a human rights exception. Contrast it with some of the, for example, the asylum seeker accommodation stuff where there are human rights exceptions. Most people seem to think the Localism Act is being used, but the Localism Act can't be used to bypass another statute. Now, there is one case, GS and Camden, where they did manage to use the Localism Act even though there was a 185 problem, but that's subsequently been thought to be wrong. Is it the Care Act? But of course, in a two-tier local authority area, the Care Act is the responsibility of the county council, whereas the district council is doing the housing. And housing itself is not a Care Act service. I mean, is this something that is just exercising lawyers because lawyers worry about eligibility? Or do you think this is actually an issue?
I fear that it will be an issue because I fear that at some point it's the people that are put back on the street or put back in transient housing where these issues will come to the fore. I must admit, I've really grappled with this knotty problem myself as well. And I do wonder, one of the things I wanted to ask you, Justin, is the fact that local authorities have been asked to accommodate people, irrespective of a request, but irrespective, potentially, say if you're an immigration offender, well, that person will be accommodated, even though the courts have said you can't apply. Is that not a strong argument for someone who wants to make it subsequently, who says, well, you know, these actions might have been within Part 7, depending on the factual, the facts, but they might not have been. You know, this was local government acting in accordance with the instructions of central government. Isn't that kind of?
Yeah, I mean, this is kind of where you and I had got to when talking about it. Is that we wondered if one of the ways round this whole eligibility problem might not be just to say that they're not acting. Local authorities aren't acting as a local authority under Part 7. They're simply acting as agent of central government, and central government can do whatever it wants. If it wants to house someone, it can house someone. But it seems to me there's two problems with that. First is that Luke Hall's letter of the 28th of May gives you no support for that idea whatsoever. And secondly, that's not really consistent with the funding position, is it? Because we know that funding is eventually going to stop, yet they nonetheless, central government nonetheless expects local government to continue to house people. And that's a strange setup if you're acting as agent for central government. Where I think it becomes, I like the idea of local acting as agent for central at an intellectual level. I just wonder if there's any evidential basis for that. It's just something you and I made up to try and get around this problem. Where I think it's going to become a real issue, though, is look, 2 years from now, when coronavirus has eventually gone, someone who's not eligible for assistance, but is really, really vulnerable, and it's December and there's a flu, a really virulent flu going around, they rock up and they say, house me. You housed all those people in coronavirus time, and whilst flu is not a pandemic on the same scale, I'm really, really vulnerable and I will die if you don't house me, if I catch flu. What's your answer then as a local authority?
In normal times, it would be a question of, well, do you meet the test, the social care test?
Yeah, it would be, can we get you into the Care Act?
Are you not only destitute, but you are going to suffer, significant harm?
But of course,
the precise wording of the case.
Yeah, the Care Act test that you need care and support, isn't it? Not care intention. Care intention used to be the 48 Act test. It's now care and support. Yeah, that might be part of the answer to it. Then we end up with potentially quite unattractive fights between district and county councils about whose responsibility it is. But what's going to be your answer as a district council to the question, why are you not housing me? You housed me 2 years ago under coronavirus. What's changed?
There is no longer a national emergency where we're working in tandem with central governments to meet that emergency.
But that's not the law. I mean, there is no national emergency brackets, let's be nice to everyone, close brackets act. I mean, that may be the policy answer, but that can't be the legal or structural answer. Can it?
Well, let's remember. I mean, I'm not sure I have an answer for you, Justin. But if people approach and they may be eligible, there's nothing to stop them applying under Part 7.
Yeah, agreed. Let's assume they are obviously not eligible for the purpose of this discussion. It is an American tourist who just happens to be in the country and has somehow managed to apply as homeless.
I can't see that a local authority 2 years down the line is going to start assisting such people merely on the basis that, oh, we've done this before.
No, but what's going to be your answer when you're challenged? Because although my American tourist in my silly example here, although he isn't in the country at the moment being housed, he's gone to solicitors who remember that 2 years ago you housed everyone without ever inquiring about eligibility.
Well, yeah, but if we go back to basic public law principles, that doesn't mean that the local authority are acting incorrectly. You need to know the law, and for example, you can't say, well, this has created an expectation. You know, to have a legitimate expectation, for example, there must have been a specific, clear promise in layman's terms. You know, that's not how the lawyers describe it. And it must be unreasonable for the local authority to resolve from that promise. I can't see what the public law argument your American tourist has if they say, well, Part 7, nothing. Social care might be something different.
But that's an answer to a different question. The question that the American tourist in my example has asked is, under what power were you acting 2 years ago? Now, you're right. The answer might well be, I'm not telling you, it doesn't matter, because at the moment you have no right to be helped. And look, I mean, as a litigator, that's obviously an answer you might run. But just conceptually, I mean, what power are they acting under?
I don't know, and I think this is the problem where we're in a public health crisis, and it's kind of classical stuff, isn't it? You read sometimes books about what happened in the 1930s, and you know, crises, and this is a legitimate crisis where, oh, hang on, public bodies are doing something, but the law and the policy hasn't caught up. You know, you've got to kind of a clear separation. It seems to me at some point, unless everyone is subsequently housed, which I can't really foresee, you know, it's going to have to be answered by the courts, because I don't know the answer.
Yeah, and that's why I find this so frustrating. I mean, you said at the beginning, no amendments to Part 7. I mean, this would have been a relatively easy amendment to do. You know, for the next 6 months, Section 185, the Secretary of State has a power to disapply it, and he therefore disapplies it for everyone who is affected by the coronavirus pandemic. That'd get rid of the whole problem. It's the fact he didn't do it. That's where this confusion arises.
Absolutely.
Yeah. Right, let's last bit of our Part 1 talk then, and just the minor matter of, are you homeless, and how does coronavirus impact on that? Now look, you all know on listening to this webinar, you know the elements of homelessness. Do you have no accommodation at all because you have no right to occupy anything? Do you have accommodation but you can't actually access it? And is it reasonable to continue to occupy the accommodation? A lot of these questions get or raise issues that are relevant to the pandemic. So, for example, one thing I think is quite interesting, and we'll talk about these in a little bit of detail later on, but does the concept of accommodation not being available to you change because of the pandemic? So, for example, you are an individual who is required to shield because you have a very serious underlying health condition, but you live in a property with non-shielding individuals, and let us say perhaps they might even be key workers working in the most overstretched hospitals imaginable. Does it mean that accommodation is not available to you because the medical guidance to you as a shielder is that you should be not interacting at all with any such people, with people who are dealing with the outside world. I think more obviously it's in the reasonable to continue to occupy stage, because people lost their jobs and they're not going to pay their rent. Has the accommodation now become unaffordable, so it's become unreasonable to continue to occupy? What about people who are living in properties where they're now exposed to a risk of domestic abuse that perhaps wasn't as great a risk before? I mean, I'm sure you've all seen the press coverage of the DV having gone through the roof since the lockdown. And just generally on reasonable to continue to occupy, the risks to health, the obvious risks to health posed by the coronavirus pandemic. So let's explore a few of those. Can we start, because I know this is one you're really interested in, with affordability. We've got there on the slide a brief bullet point summary of what Samuel said at the beginning of 2018. 2019, sorry. And how we now look at how we're supposed to assess the question of affordability. I mean, how do you see coronavirus impacting on that, Mark?
I think this is possibly one of the areas of real difficulties for councils. And I think, I hope I'm wrong, but looking forward a few months, when tenants start getting, landlords starting getting itchy feet because people haven't paid their rent or have not been able to pay the rents, which are, as we all know, are very expensive. The difficulty is that potentially you have a very, very large number of people who can quite legitimately go to their local authority and say, well, okay, I might have enough money to scrape together to pay my rent. But if I pay my rent, I can't actually pay my living costs. I can't actually pay my essential bills. And it doesn't have to be just that, does it? Even if somebody can meet their housing costs and can meet the essentials of life, if they can't meet reasonable living expenses, then they are legally homeless. That accommodation is effectively, it's not reasonable to continue to occupy. And the problem here, of course, is because not only have people lost their income, but if they're claiming benefits, there's a waiting period. The benefit levels don't necessarily allow them to live and pay housing costs and necessities of life and reasonable living expenses. Looking at it through the other end of the telescope, I think there's a real opportunity here for advocates to say, well, this person is legally homeless. What are you going to do about it? It's up to you, local authority, to plug the gap. Unless you actually find money through your homeless prevention payments or the discretionary housing payment fund or otherwise, you are legally homeless. This person cannot pay those three items.
Yeah, I mean, we'll look at this tomorrow, but I mean, I think that's right. And provisionally, I can't see how that person could be intentionally homeless.
I think intentional homelessness, we're going to have not a lot to say tomorrow, because I really do think it's a dead duck. Are you as a homeless manager, are you really going to have officers, staff with the time to kind of investigate all of the cases that are going to come to you where they're saying, well, I lost my tenancy because I couldn't pay my rent. I've
got one IH scenario for you that I do think will play out, but I'll hit you with that one tomorrow. But no, I mean, I think you're right. People who the reality of the pandemic and people losing their jobs means that we are going to see, if not immediately, but over the course of the rest of this year, people who find themselves in a position where they are in contractual rent arrears, leaving aside the fact that possession claims can't start for the moment, but they are in contractual rent arrears. They're going further and further into debt every month. It was perfectly reasonable to take the tenancy on. Indeed, they may have paid that rent for years and years and years. So what's the authority going to do? Is it just going to have to step in and pay the shortfall in order to avoid a full Part 7 case? Do you do it all under, as you say, the relief duty, or do you try and get a DHP in first so that there's not even a need to trigger the relief duty? In practice, it won't make it.
There's a couple of questions there. Where do you... I mean, you don't necessarily... I mean, if you can scrape together a DHP and plug that gap, you know, initially, I mean, I appreciate our friends and, you know, in local authorities a hard stretch, and they won't necessarily be able to act this quickly. But if you can plug that gap quickly, then there is the possibility where you can say, oh, by the time the following week, the week following their actual request for assistance, we've plugged the gap, they are no longer homeless. But I think that leads us on to another problem, and it leads us back to the Birmingham and Alley case. Because remember, one of the key things about Birmingham and Alley, I remember when the judgment was handed down, and, you know, it kind of separated suitability from reasonable to continue to occupy. We always used to think, well, they're the same, they're different sides of the same coin, and Birmingham and Alley said, well, no, they're actually different. And I think here, might it be a case of the Birmingham and Alley judgment is actually finally kind of biting councils on the bottom, because it's not just that someone can afford their rent and their food and heating and living expenses today in the here and now. As Samuel's made clear, relying on that, Alley, it's looking forward. Reasonable to continue to occupy going forward. So there's another difficulty there, it seems to me, for homelessness managers and homeless officers, in that, well, okay, well, you might have sort of got a DHP off your friends in housing benefits, but lots of DHP, lots of the housing benefit teams I know only grant it for 3 months.
Yeah.
Well,
yeah, I've never seen a DHP for longer than a year. That's a fair point.
So, I mean, in a lot of councils I work with, 3 months is pretty the standard at the moment. So how can that be? Well, the applicant's question then is, well, okay, what happens at the end of 3 months? I still haven't got enough money to pay my rent or my living expenses or my essentials. I don't really see how that that can be kind of that circle can be squared unless you throw money at it, and there is a finite amount of money. And I suppose here we're back to kind of the basic public law problem, is that if I was a homeless officer and they had a solicitor saying, well, you're going to have to accept the relief duty unless you give us some money, well, there's a real risk there where, well, you pick people off, you kind of give them the money, the people that shout the loudest get the money until there's nothing left in the budget for, you know, the other cases.
Can I ask you what you think about arguments to do with reasonable to continue to occupy based on the quality of the accommodation? So I suppose, for example, the scenario, someone who's shielding but they've only got a room in an HMO, is it reasonable to continue to occupy? Someone with kids, no access to a garden, autistic kids in particular, let's say, someone who can demonstrate a medical need for a garden.
If I was
or how about this one? Sorry, just one more to hit you with. I have actually prepared some scenarios here. I'm not just making it off the top of my head. What about you're a shielding family, so your kids can't go back to school yet, but there's no access to the internet in your property. It's not connected to super fast broadband, let's say. Reasonable to continue to occupy?
Stretching it there, possibly with the third. But if I was an applicant, certainly, and certainly if there was a risk to my health, I would certainly be making the argument, well, yes, I might have accommodation, I might have a legal right to occupy it. It might even be physically available for me, but it's not reasonable for me to occupy it. And of course, it always depends. These arguments are always very fact dependent, aren't they? You know, because the Act says, well, there's a catch-all category here. It's not affordable. It's not just you're at risk of domestic abuse. You can bring anything to the table. I don't see any reason why not. In principle, you can make that argument. But the difficulty I would see for an applicant there, certainly if the housing officer has their head screwed on, is, Well, I can undertake this comparison exercise. I can compare your situation with the situation typically arising in the borough. The Act talks of the general housing circumstances prevailing in the district. So it enables you to look at their circumstances and think, well, is it really so bad, your circumstances, whatever it is, risk to health, difficulties with pursuing your education because of internet? I think that's a bit of a stretch. Is it really so bad in comparison with what everyone else is experiencing in the borough that it's really not reasonable for you to continue to occupy looking forward for such period as you will have to until that problem is resolved or until we secure your alternative accommodation? And the difficulty I see for the applicant there potentially is that the council might turn around and say, well, hang on, we're not comparing your circumstances with the housing circumstances in January. We're comparing your housing circumstances with the circumstances prevailing at the moment. And surely that incorporates, to some extent, depending on the particular factual scenario, the difficulties people are experiencing in relation to that problem, given the COVID crisis.
Okay. We've been going for just over an hour now, so we should probably stop this, assuming that everyone hasn't just given up and left already. As I said at the beginning, because we've had to pre-record this, for which I am again sorry, we can't take questions here and now, but if you do put them into the chat section, then we'll pick them up tomorrow and probably after the end of the second one. Alternatively, if you email webinars@landmarkchambers.co.uk, then we can try and pick them up tomorrow as well. And we will try and tidy up at the end of tomorrow's session. Tomorrow, if we haven't put you off completely, we're going to do intentionality, ending the duties themselves, and any other matters that arise still to be covered. So thank you very much, and hopefully see you all tomorrow.